2023, presented by myself and Ian Heaphy. The agenda for today can we move to the next slide? The agenda for today, I'll do introductions first of all, and then I'm going to take an overview of the January 2023 amendments. I'll cover most of the amendments and give some explanation as to what they are and why we've made those changes. Then Ian will take over and deal with, in a little more detail, some changes to X22, early contractor involvement, and to the schedules of cost components. I'll spend a little time just explaining some of the resources that's available and actions that can be taken by you people. And then we'll have probably 30 minutes or so, 20 or 30 minutes for questions and answers at the end. If you've got some questions, there's a little pod there to show how you can add questions into the system. Just type those in as we go along, and we'll pick up those during the session and hopefully deal with all of them during this presentation. So the speakers, myself, I'm Peter Higgins. I'm chairman of the NEC4 contract board. I've been involved with the NEC contracts now for some 20 or 30 years, starting with early days on the first edition of the professional services contract. I was involved in the preparation of the third edition of the contract and the fourth edition, and obviously involved in the amendments that have been made since then, and some of which we're talking about today. Ian?
Hi, good afternoon or good day, wherever you may be in the world, and welcome to today's webinar. So yeah, my name is Ian Heaphy. I'm also a member of the NEC4 contract board. I also act as a consultant for NEC, providing advice and support to clients, contractors, consultants in successfully adopting the use of the NEC contracts. I've been involved for quite some time, not as long as Peter, but heavily involved in drafting the fourth edition of the NEC contracts and involved in the latest round of amendments that we're here to talk about today.
Thank you, Ian. Well, moving on to the amendments then. Firstly, just a simple overview. As you're probably aware, we released the fourth edition in June 2017. After that, we also produced an alliance contract and then facility management contracts. So we built up the family, so it's now, we think, complete, having contracts for all purposes. We've issued amendments in 2019, 2020, and now obviously the 2023 amendments. Now, you need to be aware all these amendments are cumulative. In other words, the January 2023 needs to be added to the 2020 and the 2019 amendments to get the current contract. The contract documents, either both the paper and the electronic published versions, gives you a table of amendments in each contract, so one can identify which amendments were made at which time. And in addition to that, we've annotated every page which has been amended, so you can tell whether there is something which is different from the first published edition. Now, the details given in the contracts in the table of amendments are fairly brief. If you need to know some more details about precisely what the amendments were in various editions, for example, to be able to track changed contracts from an earlier version that you're used to, then you can get that and explanatory notes available as a free download from the NEC contract website. One goes to the website, clicks on resources, and you'll find links there to the downloads for the contract changes, and you can find all of those changes from the 3 amendments issued on the website.
Peter, perhaps also just worth mentioning there as well that the user guides that are produced have also been updated with each of these sets of amendments, and so the user guides are reflective of the latest version of the contract, though we do not notify within those documents the changes made to the user guides. We note the changes in the contracts themselves.
Yes, thanks for that, Ian. Yes, we amend the user guides to deal with the changes here, because obviously it would be a bit weird to have a user guide which refers to an out-of-date contract. So they've all been updated as well. Okay, moving on. The next slide is showing some of the amendments we made to X29, what we try to do there. We're not going into a great deal of detail because we've had a separate webinar and there's been other papers on this, quite detailed discussion. It's hot topic. This is all about climate change and how we handle it. Now, we've added in X29 to each of the main contracts. We decided that all of your suppliers involved in this, in the project, whether it be consultant, contractor, subcontractor, supplier, should be involved in looking to see how they can work with the client in achieving the client's objectives. Now, what the contract clause doesn't do is to tell you what those objectives are. They are set by the client. What this does is provide a tool, a way of specifying your requirements and needs, what your particular objectives are, and putting those in the contract. And it gives a mechanism for doing that. So the starting point is that the user, the client, must state the climate change requirements, what they want to achieve, and set those out in the scope. Now, these will usually be related to business objectives. An organization will have its objectives to achieve certain climate change requirements, and will look to see how it can put those in the contract to help so that the contractors and consultants can help them to achieve these objectives. So those climate change requirements need to be specified by the client, and they will need further advice from outside as to how to get those in place. They do need to be pretty objective. They need to spell out what you're looking to achieve, and how you're going to achieve it is up to the contractor, but then the client needs to have a way of measuring whether it's been achieved. Having a requirement in the scope which is very subjective and is difficult to decide whether or not it's been achieved or not is not a great help. So we're looking at having measurable objectives in the scope. Having got that, the supplier's task is to produce a plan to set out how they're going to achieve these objectives, how these requirements, their strategy for it. Project manager, service manager will look at that and will take a view as to whether it's realistic, it's going to achieve those, have some discussions with the contractor, consultant as needed to get out a realistic climate change plan, which one would hope would achieve these requirements. We can use a performance table to set financial incentives. We can set an incentive payment to be made if targets are met. And this again is important, that the targets are measurable and they're pretty well objective targets rather than subjective ones. Setting financial incentives and then arguing as to whether or not a target's been met is not a brilliant way to run a contract. Some contracts have a table already in them. The alliance contract, the facility management contract, the design, build and operate contract. But if your other contracts which don't have one, this clause will allow one to be created and allow targets to be set within that.
So Peter, I assume then in those contracts that already feature a performance table, so facilities management contract as an example, then the climate change targets would be included in that, along with the other more general performance targets that may be set.
Yes, the process for dealing with performance and making payments for performance would be the same as in those contracts, FM contracts, etc. And therefore, there's no point in having a separate performance table. We just link them together. They're the same thing. So one adds into the existing performance table the climate change requirements as well as other performance requirements. Thank you.
Okay, Peter, if I may just mention as well, there is a working group that is being created in relation to secondary option X29, trying to identify examples of good practice, trying to sort of put the flesh on the bones around what the climate change requirements could contain, what are sensible targets to include within the performance table. So there has been a post about that on the NEC website. If people are interested in getting involved, they can communicate with the NEC separately and directly in relation to that.
Good. So you're looking for contributions as well as other issues. I presume then that when that reaches a stage, there'll be some document published, which gives guidance to people to help them to use this.
Yeah, that's very much the purpose of the group: capture best practice and then disseminate that, help to actually start to give people the detail to include in their contracts or examples of it that they can consider as a basis for their own particular requirements, though they will obviously have to be specific to the particular contract and client contractor requirements.
Yeah, thank you. Okay, moving on. Use of design. We've got a clause in the contract which says that the client can use the contractor or consultant's design for other purposes, typically for rebuilding, maintenance, repair, whatever, but also for other purposes specified in the contract. But there was debate being raised, people raising questions as to whether or not this included the documents, drawings, etc., that were provided by the supplier as part of that design or along with the design. Now, we thought they did, and it was pretty straightforward, but people have been raising questions about it, and we decided rather than letting the lawyers argue the case and a judge decide it, we would make it quite clear that they do include it. So we've now included in all the main contracts with include design that the documents provided for the design, prepared for the design, are also something the client can use, just avoiding debate and argument over the issue. An option W2. This is the dispute resolution option that complies with the Housing Grants Construction Regeneration Act. Within there, we had a number of provisions there which spelt out what the adjudicator did in terms of procedure, timescale, etc. Well, actually, the adjudicator decides the procedure and timetable. So the adjudicator is free to decide something which is different from what we said. And we've made provision for that. It's something has to be done at a certain time unless the adjudicator agrees otherwise or whatever. So what we've now done is to clarify that by saying, including a clause that says the adjudicator decides the procedure and timetable for the adjudication. And that allows us to remove a couple of items within the option where we were trying to specify that in advance.
Peter,
slide.
just to go back a moment, Peter, there's a question on X29 and the question's been raised, as well as performance targets, would it also be a defect? I'm assuming that's in relation to if a target in the performance table isn't achieved, would that constitute a defect?
Well, Ian, you're the specialist on X29, having done a webinar on this already. I'll let you answer that.
Okay, so the answer is no. The idea is that the climate change requirements that form part of the scope are things that the supplier has to achieve. If they fail to comply with the scope, that will be a defect. However, defects are, in terms of the ECC and those contracts where we create an asset, are in relation to the finished asset itself, as opposed to how the works are provided. And so the performance table can be used to incentivize compliance with the scope during the delivery of the works, whereas defects are in relation to the finished product. Slightly different in the service contracts, where often the provision of the service has to comply with the scope and it will be a defect. But the general principle is climate change requirements must be achieved. A failure to do so will be a defect under the relevant contract. And then the performance table is targets in excess of that, in addition to that, that are rewarded through the financial incentive and may not and will commonly not be a defect, because the way they're dealt with is through the performance table, as opposed to there being a second hit in terms of also having a defect and potentially costs being deducted in relation to that failure.
Okay, thanks, Ian. Can we go on the next slide? Amendments to the engineering and construction short contract. Now, in the main contracts, we've got an option to allow the contractor's liability for design to be restricted to that of reasonable skill and care, as opposed to an obligation to provide the works in accordance with the contract, full stop. Now, we didn't have that in the short contract, and people have been raising it and saying, well, they'd like this in the short contract because that makes it easier for us to use it, more readily available to use it, because we want to use that rather than the full contract, but we also want to have a limit on design. So we've taken that on board, and we've now introduced this option within the contract. So there's a clause which allows for the obligation to be limited if stated in the contract data. So there's an entry in the contract data which allows you to state whether or not the contractor design is so limited. It's a simple yes/no statement. Now, if the limitation is to be reasonable skill and care, then the contractor is expected to provide insurance to cover that liability, professional indemnity insurance. Now, we've also introduced a compensation event if the contractor corrects a defect for which it's not liable, as it exercised reasonable skill and care. Now, clearly there's likely to be a bit of a debate about whether or not reasonable skill and care was exercised, and it may not be a straightforward event to decide whether it is a compensation event. But at the end of the day, if the project manager, adjudicator or arbitrator decides that the contractor did exercise reasonable skill and care, then it is compensated for any additional work that results from putting right the defect. We've also, of course, included similar provisions in the engineering and construction short contract. So the subcontractor, short subcontractor. Start again. In the engineering and construction short subcontract, so the subcontractor has the same protection. On the next slide. On other short contracts, professional services contract, we put the same compensation event in if the consultant corrects a defect for which is not liable as it exercised reasonable skill and care. Now, the same arguments apply on that one, but at least we've now got a clear statement that it is a compensation event if that work is done. The short supply contract, we established that the way of payment was made if the termination was due to purchase of default or purchase convenience. In the supply short contract, it was different from in other contracts where we decided that we ought to have the consistency and they should be the same. So we've amended the short contract so that the payment is the same as that in all other short contracts. And then finally, in all short contracts, a clause being included to allow a limit on liability to be included. Now, this again is reaction to requirements and requests from industry saying that they actually wanted to limit it because they were finding trouble in bringing smaller contractors into place with unlimited liability. So we've introduced a clause there which allows limits to be placed on liability. This can be in terms of damage to the works, failure to the works, or indeed in total on the contract. It's optional. It's a matter of whether or not you include it. If you include it in the contract data, then there is a limit applied. The way that it's written is the contract data specifies, and I guess to be quite sure on this one, if you're not having a limit, if you want unlimited liability, you need to include that statement in contract data. Moving on. In the facility management short contract, we've added a provision to clarify that the service provider is liable for loss or damage to client's property. It was there in terms of the client not having the liability, but it wasn't clear that the service provider had that liability. So we clarified that by adding in a provision within the clause 81 to specify that. And because of that, we've also now included the ability for the client to limit that liability in contract data in the same way as other liabilities are limited. Now, again, we've included the same provisions in the facility management short subcontract. So the subcontractors and the main contractor has the same provision. And in the case of the subcontractor, it can apply to the main contractor's property as well. Okay, I now will move over to Ian to take us through on the X22 early contractor involvement.
Okay, thank you, Peter. There has been a number of questions that have come in. Thank you for those. We'll answer those at the end. We'll just work through the remainder of the slides for now. So looking then at X22, this deals with early contractor involvement. It's only contained as an option within the ECC, the engineering and construction contract. So it does feature in the alliance contract as well, but the changes here have been made to the version that features within the ECC that is intended to be used with main options C and E. So what we've tried to do here is provide further clarity around how the process should work, particularly in relation to stage one and what happens if the works don't proceed past the end of stage one. And also we've tried to introduce additional flexibility in how the project is developed during that stage one, allowing it to reflect what we're getting as feedback from users as to how they are seeing it operated in practice. So one of the changes we've brought in is the ability for the project manager and contractor to agree to change the site information during stage one. Very often we were seeing situations where a primary function in stage one was there to be investigations, to undertake further site investigations, to ascertain what it is we're likely to encounter when we provide the works. And so that would allow additional information to be gathered, and the view was that that should then be brought into the site information, because that is a document that we will then use to assess compensation events during stage two. And to reflect the fact that we can have updates to the site information occurring in stage one, for those compensation events which were originally judged against the contract date, so the date of award of stage one, those will now be judged against the date of the notice to proceed to stage two, if such a notice is given. So the idea is to allow the prices, the program, the scope, the site information agreed as applicable for stage two, that is now able to incorporate the information gathered during stage one. That will be included in the price of the program, and therefore if there is a compensation event, it should be judged as of that date, only considering risks or unforeseeable events from that point forward. So that's the first element of changes. We move to the next slide. What we've also tried to do is simplify the administration of compensation events in stage one. What you always have to remember is that X22 is a secondary option. The core clauses will still apply to all of the work undertaken in both stage one and stage two, which means that we need to go through the process of notifying compensation events for things such as changes in scope instructed by the project manager. And so that could mean there's lots of changes occurring as stage one is developed, leading to lots of compensation events arising that we maybe don't want to deal with individually, that maybe we're actually going to sort of roll up and deal with as part of the setting of the prices, the program for the stage two works. And so we now have this clause that says when we get to stage two, when we issue the notice to proceed to stage two, that is going to include the effects of all compensation events notified to that point in time. So that means that you can, if you're working on the job, project manager, contractor can agree to extend the time periods for reply to compensation events to allow them to be dealt with as part of that wrap-up procedure, maybe agreeing the value and the time effects at zero for the purposes of administration, and then dealing with the consequences as part of the notice to proceed to stage two.
Yeah, would there be times when the project manager contractor would want to deal with the compensation event and assess it properly during stage one, or do we just forget about them?
No, absolutely. And there was a debate around whether we completely sort of exclude the CE process in stage one. In effect, it's a cost reimbursable stage. If it doesn't proceed to stage two, then there's limited effect to any compensation events that may have occurred in that stage. However, there was still a view that we need to maintain that process because, as you say, there may be those changes that will affect how stage one is delivered, that may lead us to maybe change the completion date for stage one if we have maybe a sectional completion date for that stage of it. So there may well be reasons as to why we do want to manage changes through that mechanism in stage one and not just defer them all to the notice to proceed to stage two.
Thanks. Okay.
Another thing that we've done is that we have changed the reference that was contained originally in X22 to allow additional scope provided by the contractor in stage one to become scope provided by the contractor for its design. So we remove that statement because partly it was a bit of an odd statement that it stood alone without any sort of submission or acceptance process to work around it. There was no mechanics of how that actually happened. And also because we already have clauses to deal with that. We already have the ability of the project manager under clause 14.3 to issue an instruction changing the scope, whether that's the client scope or the scope provided by the contractor for its design. If that is made at the request of the contractor, it's not going to be a compensation event. It would again be wrapped up as part of that, part of the contractor's proposals for stage two and addressed through any changes in the prices, completion dates and key dates as part of that mechanism. So we felt we didn't need to have a separate process. And so we've removed that reference, but still obviously allow that to happen through the core clauses already within the contract itself. Move to the next slide. Another thing that we've done, and this again was largely based upon user feedback, was to tidy up the process if the works didn't proceed to stage two. We had quite a lot of provisions in the previous drafts around if it proceeds to stage two, what happens, but there was maybe a lack of clarity over what happens if it doesn't. And so what we've introduced now is the requirement for the project manager to formally issue a notice to the effect that the works will not proceed to stage two. And then that triggers a number of actions, the primary ones of which are that the completion date and the prices are changed to match those at the end of stage one. So this is trying to make it clear that there shouldn't be delay damages applied at the end of stage one. There shouldn't be any assessment of the contractor's share under an option C contract. That first stage is very much a collaborative process to agree the stage two works, paid for on a defined cost plus fee basis, allowing us to work together to create the stage two proposals. But if we don't proceed, we pay the contractor for what they've done. Both parties can walk away without consequence, and the client in certain instances can then procure somebody else to provide the stage two works. That also makes it clear there's no incentive payment due unless the works proceed to stage two. And also we've clarified the amounts due on termination in relation to the works that only end at stage one or are terminated during stage one. I think a lot of these things were sort of self-evident and obvious in the previous drafts. We've just tried to make it clearer to avoid any arguments that may be raised around this, just to provide that further clarity over how it's intended to operate. We go to the next slide, please. So that's X22, changes in relation to that. The other point that I'm going to highlight is the changes that we've made to the schedules of cost components. So this is relevant for those contracts that have reference to working areas or service areas. And so under the previous editions, we allowed for people to be claimed as part of defined cost when they were working within the working areas or service areas. That then evolved to allow people who are normally based within the working areas or the service areas to be included in defined cost wherever they were working if they are normally based within those areas. But that still created a potential issue that was very much highlighted through the COVID-19 pandemic, where we had people working from home. And that's created a bit of a shift in certain types of roles in certain locations where people are perhaps now permanently working from home. People who would otherwise have been based on site within the working areas or the service areas are now working remote. So they don't satisfy that criteria of being normally based within the working areas or service areas, or there can be debates as to whether they're covered by that. So to give clarity and flexibility, we've now introduced an additional category of people. So people who can be claimed as part of defined cost, even if they are not based within the working areas or service areas, even if they are not working within those areas, so working from home or what have you, those people can be included in defined cost if they are added into the contract data part 2 as people who fall within that particular category. So the idea is to pre-agree those people who can be recovered as part of defined cost wherever they're located, as long as they are providing the works or service and they are on that list of pre-agreed roles. We've also introduced the ability with that as well for additional people to be added into the listing, in the sense of we don't have the ability for the project manager, service manager, contractor, service provider to agree to change the contract data. So we can't add to the list post-contract award, but there is a provision that says with the project manager or service manager's agreement, additional people can be treated as if they were originally listed in the contract data, therefore allowing that list of people, of roles, to be changed as may be necessary as a result of compensation events, etc.
So, Ian, how does the project manager decide whether to agree to that? Because there's no test, is there? There's no restriction on it.
Yeah. So this can only happen with the project manager's agreement. It's not as if the contractor submits a proposal and the project manager should agree unless one of the reasons stated in the contract as to why they can say no applies. So it's very much for the project manager to make that decision. But what they should do is look at the sort of bigger picture, that if there is, for example, a compensation event, if that means the contractor needs to engage additional people to work on the contract, then there'll probably be a conversation about whether they can do that work remotely or whether they need to be placed on site within the working areas or service areas. And so that you would consider what would be the cost of the accommodation within the working areas, service areas for them, the attendant costs that would be incurred compared to the cost of them working remotely from home. And hopefully that should drive a sensible decision based on what the resultant cost would be to the contractor, service provider, and then ultimately to the client under these cost reimbursable options.
Okay.
And maybe just worth noting that those people who are agreed to be charged, even though they are outside of the working areas or service areas, will be recovered based on the actual cost the contractor or service provider pays them, as opposed to on a rated basis or a rate to be agreed type basis. It is based on actual cost.
Thanks.
Okay. We've also made a small tweak. If you go back a slide, sorry. We've also made a small tweak to the shorter schedule of cost components, or rather, I should say, the short schedule of cost components, where we have just slightly expanded the definition to say that as part of defined cost incurred as a result of a compensation event, you can also, as the contractor service provider, include the costs of people who are normally based within the working areas, even if they are working outside of it. So we haven't gone as far as in the full schedule, bearing in mind that we only use defined cost under options A and B to deal with the effects of compensation events. So we have slightly expanded it, but not to the same extent as the full schedule, because, as I say, defined cost serves only the purpose of assessing the effect of the change to the prices when it's used with the short schedule of cost components. Final thing to mention, we've also got rid of the distinction between directly and indirectly employed staff in terms of their working location in both the short schedule of cost components and the full schedule of cost components, recognizing that there was a bit of an artificial distinction being drawn between directly and indirectly employed staff. We've got rid of that, though we still have a different basis of assessing the cost. Directly employed staff, actual employment cost; indirectly employed staff, amounts paid by the contractor or service provider to the individual or the company providing the individual. So that's a summary of the changes. I think, Peter, over to you to talk about some of the NEC resources and other updates.
Yeah, just a very quick session to give us plenty of time for questions. You may be aware of the community platform, a simple app on your phone, which gives a load of information about the NEC. Some of you may well be already registered for that, but if not, I recommend getting registered. Have a look at it, see what you can see on there. There's some useful stuff. A lot of people getting involved in various comments and ideas, so it's well worthwhile having a look at that as part of your options within your phone. Second one we want to look at is just a reminder about the annual conference. 13th of July, live conference in Great George Street. I think it's also going to be live streamed, but you're welcome to be there. Look forward to lots of people going there. We have the annual conference and the Martin Barnes Awards, which is a fascinating showcase of some of the best practice in the industry using NEC. A useful session, so look forward to seeing you some of them there. And then finally, just a reminder of all these support services that the NEC supplies. Most of them I think you probably know about. Obviously workshops, part of user group sessions, webinars, you're involved in one now, you know about training, contracts, etc. So just a reminder, there's plenty of support services there to clients who need some kind of help and assistance, and NEC is there to provide it. Okay, can we move on now to questions?
Okay, Peter, I've got a question for you that's come through in respect of the changes to W2. Does the new option W2 clause state a time period in which the adjudicator must provide the timetable for the adjudication, the submission of the various documents required?
Yeah, no, there's no timescale for that. It's simply a matter of saying that the adjudicator has the power to fix times for anything which needs to be fixed. So if we've got a submission from one party, the second party is required to put a submission. The first party says, well, I need to put something else in. Basically, the adjudicator is then able to say what the timescale for that is. There's no timescale for when that needs to be, the decision needs to be given, because it obviously depends on what is needed and how it fits, and there may need to be a discussion with the parties to decide what that timescale is. So simple answer, no, there's no fixed timescale for that.
Okay, thank you, Peter. Another question, I think, which is relevant to yourself is around clause 22.1 and around the sort of intellectual property rights, etc. And there's a comment that is often deleted or amended through legal advice. And there was a question as to whether the amendment doesn't deal with the granting of sub-licenses, and if there's a particular reason why the right for the client to grant sub-licenses wasn't specifically covered with the amendments that were made.
Well, we don't actually refer to licenses. What we do say is that the client may use the documents and the design for certain defined purposes without trying to extract a legal license to do so. It's a simple right to do that. And therefore, if the client is able to do that, I think it's taken for granted that he's entitled to allow people working for the client to also make use of them. So if we're talking about some maintenance work, he's got a maintenance contractor. The maintenance contractor, on behalf of the client, will be able to use it. We don't need to issue a separate license for that, we don't think. Now, maybe some lawyers will disagree with that, but that's the view we take, that we're providing a right to use the equipment, the material, rather than a license of such. I see there was another question as well on that, wasn't there, if I remember rightly, on that?
Yeah, I think a brief question. Suppliers design, do you envisage issues with IP on this?
Well, of course, intellectual property is something which the contractors will be quite jealous of, but we're talking here about a design which is being paid for by the client. So the intellectual property ought to be with the client in any event. So it's difficult. The only time you might have an issue with this is if the contractor's design requires certain proprietary information which has its own intellectual property. In that case, of course, there is a requirement there to make sure that right to use that intellectual property is passed across to the client as well. That seems to be the only problem, I think, behind using that.
Yeah, and I think it's maybe just referencing X9 as a secondary option to transfer rights and IP, which is optional. And so the transference of that is something to consider from the client side. And obviously suppliers, when bidding, will consider what that will mean to them and what that would, I guess, create in terms of a change in the ownership of the IP created under the contract.
Okay. One for you, Ian. X22 requires PM to accept contractor's forecast in stage 1. Has the contractor the right to stop work until the forecast is accepted?
Okay, so the forecasts are based upon the original sort of scope that was set out in the contract, in the scope in relation to the stage 1 works. So the idea is the forecast should really be reflective of what is going to happen, and therefore hopefully will be a fairly straightforward thing for the project manager to accept or not accept. And of course, if there's a non-acceptance, reasons have to be given as to why. The response has to be provided within the timescales within the contract. Otherwise, that creates a compensation event. So, given that costs outside of the forecast are going to be disallowed in effect or not paid, I could understand the concern from the contractor that if they're saying we need more money to do something, if that isn't then accepted, they're not going to get paid for doing that on the face of it. But at the same time, there should have been an initial forecast accepted. It's only changes to that we're concerned about. And ultimately, if the project manager doesn't, in effect, authorize that additional expenditure, then, I think the contractor may have to consider whether they can continue to provide that part of the works, because it is cost reimbursable. When the money is gone, the money is gone in terms of what they do.
Okay. Okay, I don't know if you want to try to take this one. Why does X22 only apply to options C and D? Why not option A?
Yeah, it's just interesting question that has been asked before. And the view primarily is that the whole idea of early contractor involvement is to engage the contractor at an earlier point in a more collaborative way to help them create the the detail of the project for the stage 2. So, I mean, the question is really, I guess, in terms of, are you saying it should be option A for stage 1 and or option A for stage 2? Because certainly for stage 1, where that is meant to be this collaborative, we can't scope the works in advance, we're actually evolving what needs to be done, I think it'd be extremely difficult for the contractor to commit to a fixed price for that element at the very start, and would actually be counterproductive with the contractor trying to maybe cut corners or look to reduce the amount of effort they put in to make a return or avoid an overspend. And or you're going to have lots of compensation events as that stage 1 scope evolves, as that stage develops, because there may be really good ideas in stage 1, some additional investigation, some design that can be developed that will make huge savings in stage 2. So you need that flexibility and freedom to manage stage 1 on, in effect, a cost reimbursable basis. In terms of stage 2, well, given you're negotiating that on an open book basis in stage 1, given there's this idea that you're working together to create the price, the view is then that the risk of delivering to that price should be shared through option C, or if it's still quite, there's still a level of risk within it, the client should take that risk under option E. I mean, ultimately, Peter, if there's a view that you want to take that type of approach, you could engage the contractor for stage 1 under a professional service contract or a ECSC, and then actually separately sort of negotiate, tender, award a contract using an ECC option A for the stage 2. But for me, it just doesn't sit with the process we envisage that's used through early contractor involvement.
Yeah, I think the feeling we've got is that the balance of risk we've got in using it in option C is about right. If you want to use it in option A, then you've changed the risk profile, as Ian just said. And I think in that case, you need to think very carefully about what other provisions you need to deal with managing that change in risk, because the clause that we've drafted doesn't really deal with the extra risk you get from using an option A. Anyway, I'll pick up one for a minute just to give Ian a short breather there. Is there any recommended value threshold to use of the short form contract or definition of low complexity? Simple answer, no. There's no value because it can be used for any size of contract, really. It's a question as to whether the risk balance works for that particular size. So there was an example given of, I think it was in Scotland, a power supplier was using it to string a whole load of high voltage cables across the Highlands. It was a several £1 million contract, and he said it's a very simple, straightforward contract. There's no complexity to it. We use the short contract. So it's really horses for courses. And the other one I was going to pick up on was client's use of provider's design. Can the supplier's design pack be used for any purpose or for some specific purpose? Well, the clause is fairly clear. You can use it for specified purposes, which is use, alteration, demolition, maintenance, modification of the property, or other uses specified in the contract. So if you want to use it for anything other than working on this project, then you need to specify what it's there for, so the client knows in advance what it's going to be used for.
Peter, there's another one I can pick up on, which a question asked around, I'm not sure I understand what X29 does to alter the standard contract. Compliance with the scope is already part of the core clauses. Does it just bring the requirements to the forefront? Well, in part, yes. It has been created to specifically shine a spotlight on this issue to focus people's minds in relation to it. But it does bring in some additional benefits as well. We have the requirement for the supplier to put forward this climate change plan. So explaining how they intend to achieve those targets so we can monitor against it to make sure that those climate change requirements are being delivered. Also, it introduces this performance table and the ability to incentivize the supplier's performance both positively and negatively in relation to not only the finished works, but actually how they provide the works or how they provide the service. And that performance table isn't, as we've discussed, included in many of the existing contracts. It is in some, but not many. So it introduces that option into those other contracts. It may be that in 5-10 years' time, we may not need it. It may very much become business as usual. It's intrinsic and inherent in what we do. And some of those clauses move into the core clauses in future editions, but something for the future.
Okay, slightly different topic. One for you again, I'm afraid, Ian. Would the changes to the schedule of cost components allow a contractor to recover the cost of a managing director if they were specified in contract data, provided they were providing the works?
I think the simple answer would be yes. That if in contract data part 2, as part of the list of roles that were identified as forming part of defined cost, whether that person was working inside or outside of the working area, whether that person was based inside or outside of the working areas or service areas in the FM/TSC contracts, then the simple answer would be yes. But I think here, this is where you would expect, as part of any sort of tender process, any sort of contract formation, the client may want to pre-populate contract data part 2 with the types of roles they are prepared to allow the contractor to include in that list of people. I mean, ultimately, they could delete the entry. They could not have anybody. You know, the idea is that this is something that is sensible and practicable where necessary. So, yeah, you don't have to use it at all. If you exclude the entry from contract data part 2, nobody falls within this category. If you do include it, you can specify the roles in advance, or you could negotiate that depending on your tender process. So therefore, you should hopefully come up with a sensible list of people at the end of it, should you wish to adopt that approach.
Thank you. One I'll pick up on. One of the slides talks about compensation events where the consultant is correcting a defect, where the consultant is not liable. That's because they've used reasonable skill and care in the work. What if the consultant is liable? Well, it's not a compensation event, so the consultant is liable to correct the defect without compensation. That's the simple case. Of course, there may be other consequences as well in terms of what the effect, the impact of the defect on the contractor's work when the defect is found, etc. But the key point is that this is just introducing a compensation event to deal with the fact that the consultant is not liable for the defect, so they shouldn't have to pay the cost of correcting it out themselves. Another quick one, somebody was, I think, no, sorry, that one's been dealt with.
Peter, maybe one for us to debate here, Peter. There's a question here about the philosophy behind NEC. Seems to be that unless a person is working within the working areas, guessing this is specific to the ECC and those contracts, their cost must be in the fee. Some of the recent changes have sought to address this, as we've discussed. And I guess the ultimate question here is, why is the philosophy for allowable people costs not simply that they have to be working on the project? Why haven't we gone as far as that and got rid of the concept of working areas in relation to people?
Well, if you think about it, in the professional services contract, that's what we do. We've got a distinction, is that the professional services contract, we allow people who are working on the contract to be recovered. We don't specify a place where they have to be working. We do in the case of contractors, and I think this is partially historic and it partially a practical issue. Historic in that we've always thought of contractors working on site, and therefore we've identified something we're calling the working areas, which is the equivalent of saying, well, as long as you work in there, you get paid because that's what you're being paid to do. And no contractor is going to pay people for hanging around on in the site and doing nothing. So that's a sort of very sensible way of dealing with it at that stage. We've identified as sort of a number of cases where people might not be working on the site, where they might be visiting some works, they might be visiting some other place where there's fabrication being taken place. We've added in where they're working from home. We've got provision there for working on remote design. So there's a number of things we've added in, but the basic question is, can we just scrap all this and say the contractor's paid for anybody who's working on the job? That would be quite a radical change. You think we'd go that far, Ian?
For me, I'd have to say no, in that I still think that in terms of the construction contracts and to an extent the service contracts, we need to maintain a distinction that, the way the contractor normally manage their accounts, they have, if you like, overhead costs, head office costs. They then have the costs of construction. And so I think our contract sort of reflects that general split of how they normally operate. Working areas are there to create a bit of a discipline around that. Because I think if we went down the route of saying anybody working on the contract can be charged as long as they're providing the works, then we get into debates around, managing directors. What about the accounts team? What about the team that does the procurement? What about the human resources team who recruit staff? If they're recruiting staff for the job, are they then people who are providing the works? Can they be charged? And we could get into a lot of debate and discussion around every member of the contractor's organisation at a head office, a local office level. Can they be charged? The person manning reception, somebody comes in because they've got a meeting in relation to this contract. Do we proportion some of their time? I think it would just create too many questions and issues and too much variance over different contractors' approaches. So I still think we need a level of discipline around that, and I can't see that changing, but we welcome feedback.
Yeah. I mean, it sounds as though, from what you're saying there, Ian, that if we were to scrap the idea of working areas, we'd have to introduce something else, which is like a head office area, to exclude people from there. So it doesn't seem as though
absolutely. Yeah, or alternatively, we have to start looking at categories and say these people are chargeable at cost and these people are chargeable as or covered by the fee, which we've always tried to resist. Now, someone could make an argument, well, in the PSC, you don't draw that distinction, but actually we do have in the PSC an overhead percentage that is applied to cover the cost of support staff and people. And so the idea is that you would, under that arrangement, identify those people who would be charged as, if you like, consultants providing the service, as opposed to those providing that support service. So that does require a little bit of thinking when you put the contract together, but we do try to maintain a distinction there.
Okay, something for the future, perhaps, when we get to a big new contract. I think we've just got time really for one final one. One here from overseas, I think, Rob. How do you change the scope for stage 2 in stage 1? What is the flow? 14.3, but you can't deal with it as a compensation event because the prices are for stage 1 only. So what is the practical way to change the wording in the scope for stage 2?
Okay, I mean, for me, the scope, it depends, I guess, well, two things. Firstly, it depends how much scope is specified at the start. So do you only have the stage 1 scoped out when you start, or is there an initial scope for stage 2? Is there already some design, some content? And then as you work through it, if you're going to add to the scope for stage 2, particularly if you're going to change any existing scope for stage 2, then you have the normal process of, whether it's the client making those changes and reissuing the scope, whether it's the contractor proposing changes that the client may then choose to make themselves, or if it's a design and build arrangement, you may have the contractor putting forward design submissions under clause 21 in compliance with that procedure. Possibly you could then consider any contractor's proposals that are going to be incorporated as contractor's scope for its design. But I think you have that flexibility in stage 1 for, the conversations to happen, for the scope to be developed. And, you can, as we've said, in effect, park the administration of the compensation event mechanism. You can roll that together. And at the end of stage 1, say this is the client scope, this is any contractor scope for its design. It may be we have some contractor's design that's been accepted, and the price, the program, etc., agreed at the end of stage 2 is based upon those documents. And then once we're past the stage 2, we then deal with any changes to those as we would any other changes that occur under the standard contract provisions. So for me, you would just have hopefully a sensible way of working. It is cost reimbursable. Contractors are going to get paid for what they do in preparing design, offering changes to the scope, and then it's that decision through the process or at the end as to how you, as I say, categorize the scope, any contractors' design submissions, and you can wrap that up in terms of any changes to the prices, completion dates, etc., as part of that notice to proceed to stage 2. Maybe something we could consider providing some guidance on. It may be something that we can add in addition to the wording of the contract.
Yeah. Okay. Well, thanks for that. We've run out of time now. There's a few questions left unanswered. Perhaps we could look at those later and maybe circulate a note on this. I think that there's a question about publication. I think the intention is to make this webinar available afterwards to others. So hopefully we can deal with some of the other questions at the same time. So closing down now, thank you for your attendance. It was good to have those questions. They were taxing us a little bit, so they're nice, and there's a few more that's still to answer that Ian and I will try to deal with and send you the responses to that. So thank you very much again. Good to see you, and goodbye.
Thank you and goodbye.